Michigan Real Estate Exam State Law. Question 1. During a license application in Detroit, a salesperson encounters a rule involving fraud, deceit, or dishonesty in licensed practice. Which response follows Michigan law, while the file concerns an industrial site, a listing agreement, and an assumed business name? Option A. An automatic contract amendment. Option B. A protected marketing strategy. Option C. Grounds for occupational discipline. Option D. A required form of negotiation. The correct answer is option C. Grounds for occupational discipline. Dishonest conduct undermines the competence and trust expected of a licensee. In the described setting, the brokerage should document the step and apply it before moving forward. Negotiation does not authorize intentional deception. Question 2. A associate broker is preparing for a renewal review in Grand Rapids. Which statement correctly addresses gross negligence or demonstrated incompetence, while the file concerns a new construction home, a lease application, and a security minus deposit question? Option A. Conduct that can support disciplinary penalties. Option B. A substitute for continuing education. Option C. A protected advertising style. Option D. An exemption from supervision. The correct answer is option A. Conduct that can support disciplinary penalties. Serious carelessness and inability to perform regulated work can trigger professional sanctions. Applied to this scenario, the licensee should follow the rule before creating further obligations for a party. Education and advertising rules do not convert incompetence into lawful practice. Question 3. Which Michigan requirement should control when an employing broker deals with false advertising by a licensee during a property management meeting, while the file concerns a mixed-use building, assigned agency disclosure, and a dual-representation concern? Option A. A permitted team slogan in every case. Option B. A disciplinary violation. Option C. A title-insurance requirement. Option D. A method of deed delivery. The correct answer is option B. A disciplinary violation. Real estate marketing must be truthful and comply with brokerage-identification rules. For exam purposes, focus on the regulated relationship rather than an informal business custom. Deed and title procedures are unrelated to advertising honesty. Stressed about your real estate? We can take real estate for you remotely and undetected. We always guarantee a pass and payments only after results. To send us an email, scan the code or tap the link in the description and let's get it done. Question 4. At an advertising campaign, the brokerage discusses helping another person perform regulated brokerage work without a license. Which conclusion is most accurate, while the file concerns a cooperative unit, an online advertisement proof, and a protected class inquiry? Option A. Lawful delegation to any friend. Option B. A zoning enforcement function. Option C. A required referral method. Option D. Aiding unlicensed practice. The correct answer is option D. Aiding unlicensed practice. A licensee may not enable an unlicensed person to perform activities reserved for licensed practitioners. The transaction context changes the facts, but it does not change the underlying licensing duty. Calling the activity a referral does not change its substance. Question 5. A compliance question in Muskegon concerns practicing while a license is suspended, revoked, or lapsed. Which action or statement is appropriate, while the file concerns a farm parcel, a listing agreement, and a disputed repair credit? Option A. The person is treated as unlicensed. Option B. The employer may privately reactivate it. Option C. The license remains active for pending deals. Option D. Only advertising is prohibited. The correct answer is option A. The person is treated as unlicensed. Authority to practice depends on a current license in good standing. A written office procedure should produce the same result in comparable transactions. Only the department can restore lawful status through the applicable process. Question 6. How should a Michigan property manager handle a situation involving failure to comply with a final board or department order, while the file concerns a lakefront cottage, a lease application, and an electronic signature? Option A. A private contract defense. Option B. A fair housing exemption. Option C. An automatic license renewal. Option D. A separate basis for discipline. The correct answer is option D. A separate basis for discipline. Final regulatory orders are enforceable obligations of the licensee. In the described setting, the brokerage should document the step and apply it before moving forward. Private transaction terms cannot override the order. Question 7. Which choice best applies the state rule concerning the body created to regulate Michigan real estate brokers and salespersons to a team training, while the file concerns a townhouse, assigned agency disclosure, and a referral arrangement? Option A. The local register of deeds. Option B. The county planning commission. Option C. The Michigan Board of Real Estate Brokers and Salespersons. Option D. The Federal Reserve Board. The correct answer is option C. The Michigan Board of Real Estate Brokers and Salespersons. Article 25 establishes a state board for the licensed brokerage professions. Applied to this scenario, the licensee should follow the rule before creating further obligations for a party. Local land offices and federal banking regulators perform different functions. Question 8. A file from Battle Creek raises an issue about the department's role in professional licensing. Which answer identifies the governing requirement, while the file concerns a urban infill property, a online advertisement proof, and a team social minus media post? Option A. Approve all private purchase offers. Option B. A record deeds for each county. Option C. Determine eligibility, issue credentials, and enforce the occupational code. Option D. Set every property's market price. The correct answer is option C. Determine eligibility, issue credentials, and enforce the occupational code. The licensing department administers applications, examinations, renewals, and compliance. For exam purposes, focus on the regulated relationship rather than an informal business custom. County recording and market valuation are handled through other processes. Are you looking for real estate actual questions? Visit our website pokerexams.com to access real estate study guide with actual questions and answers. Scan the QR code or click the link in the description to get real estate answer key today. Question 9. Before completing a lease negotiation, which rule should the branch manager apply to the minimum age for an initial salesperson applicant, while the file concerns a subdivision lot, a listing agreement, and a record inspection request? Option A. At least 16 years old. Option B. At least 19 years old. Option C. At least 21 years old. Option D. At least 18 years old. The correct answer is option D. At least 18 years old. Michigan requires an initial salesperson applicant to have reached legal adulthood. The transaction context changes the facts, but it does not change the underlying licensing duty. Higher age thresholds are not part of the current salesperson checklist. Question 10. A Michigan exam candidate reviews a scenario involving the approved education needed before examination eligibility. Which option reflects the current licensing framework, while the file concerns a rural acreage, a lease application, and a branch-office distance issue? Option A. A complete 60 hours of continuing education. Option B. A complete 90 hours of broker education. Option C. Complete 40 hours of approved pre-licensure education. Option D. A complete 24 hours of approved education. The correct answer is option C. Complete 40 hours of approved pre-licensure education. The salesperson pathway begins with 40 approved instructional hours. A written office procedure should produce the same result in comparable transactions. Broker coursework and renewal education serve different licensing purposes. Question 11. The broker's policy manual addresses the examination provider used for the Michigan salesperson test. Which provision should it contain, while the file concerns a single-family residence, assigned agency disclosure, and a financing contingency? Option A. Pass the salesperson examination administered by SI. Option B. Pass only a school final examination. Option C. Pass a county assessor examination. Option D. Pass an examination administered by the employing broker. The correct answer is option A. Pass the salesperson examination administered by SI. Michigan uses an independent testing vendor for the salesperson licensing examination. In the described setting, the brokerage should document the step and apply it before moving forward. An employing broker may sponsor the applicant but does not administer the state examination. Question 12. A regulator asks about the step that produces the candidate identification needed to schedule the test during a brokerage review. Which response demonstrates compliance, while the file concerns a small apartment building, an online advertisement proof, and an unrepresented consumer? Option A. Schedule with SI before applying. Option B. Submit the online salesperson application and education proof first. Option C. Wait until a license is issued. Option D. Ask a broker to create the candidate number. The correct answer is option B. Submit the online salesperson application and education proof first. Exam eligibility is connected to the online application record and verified course completion. Applied to this scenario, the licensee should follow the rule before creating further obligations for a party. The identifier is not created by a school or a prospective employer. Question 13. Which statement would be safest for an employing broker to follow when the employment relationship required before an active salesperson license is issued becomes relevant, while the file concerns an office condominium, a listing agreement, and a confidential price limit? Option A. Use a title company as the statutory employer. Option B. Work independently without a broker. Option C. Register with a local board only. Option D. Obtain sponsorship from a licensed individual broker or broker company. The correct answer is option D. Obtain sponsorship from a licensed individual broker or broker company. A Michigan salesperson practices through a licensed employing broker. For exam purposes, focus on the regulated relationship rather than an informal business custom. Independent brokerage activity requires a different level of licensure. Question 14. A dispute arises during an open house over the number of brokers to which a salesperson may be licensed at one time. Which principle resolves the issue, while the file concerns a condominium unit, a lease application, and a change of employing broker? Option A. 2 brokers if both consent. Option B. No broker after passing the examination. Option C. 1 employing broker. Option D. Any number of affiliated brokers. The correct answer is option C. 1 employing broker. The salesperson license is tied to a single employing brokerage at a time. The transaction context changes the facts, but it does not change the underlying licensing duty. Consent between firms does not create an exception to the 1-employer structure. Question 15. In Holland, a listing licensee must decide how to proceed with whether a person may simultaneously hold salesperson and broker licenses. Which decision is consistent with Michigan requirements, while the file concerns a retail suite, assigned agency disclosure, and an owner-licensee conflict? Option A. Both are allowed if issued in different counties. Option B. Both licenses may remain active indefinitely. Option C. The restriction applies only to associate brokers. Option D. The person may not hold both license types at the same time. The correct answer is option D. The person may not hold both license types at the same time. Michigan separates the salesperson credential from broker-level licensure. A written office procedure should produce the same result in comparable transactions. County location does not alter the statewide licensing classification. Question 16. Which exam answer accurately classifies the rule involving the usual validity period of initial salesperson pre-licensure education, while the file concerns a manufactured home site, an online advertisement proof, and an expired license issue? Option A. 5 years from examination. Option B. 30-6 months from course completion. Option C. 1 year from application. Option D. 6 months from enrollment. The correct answer is option B. 30-6 months from course completion. Initial salesperson coursework remains usable for a 3-year period after completion. In the described setting, the brokerage should document the step and apply it before moving forward. The examination and application have their own shorter validity periods. Question 17. A new policy is being drafted for the usual validity period of a passing salesperson exam result. Which language belongs in the policy, while the file concerns a 2-unit rental, a listing agreement, and a property-management payment? Option A. 90 days from testing. Option B. 1 year from the passing date. Option C. No expiration after passing. Option D. 3 years from testing. The correct answer is option B. 1 year from the passing date. A passing licensing score is time-limited even though it has been reported to the application. Applied to this scenario, the licensee should follow the rule before creating further obligations for a party. Course validity and license-cycle length do not extend the score period. Question 18. During team training, the supervising broker tests knowledge of the usual validity period of a paid salesperson application. Which answer should the team select, while the file concerns a historic residence, a lease application, and a delayed possession term? Option A. 30 days from submission. Option B. Until the applicant chooses to reactivate it. Option C. 1 year from the payment date. Option D. 2 years from course completion. The correct answer is option C. 1 year from the payment date. The online application remains open for a defined 12-month period. For exam purposes, Focus on the regulated relationship rather than an informal business custom. A valid course certificate does not keep an expired application open. Stressed about your real estate? We can take real estate for you remotely and undetected. We always guarantee a pass and payments only after results. To send us an email, scan the code or tap the link in the description and let's get it done. Question 19. A consumer asks the brokerage to explain the requirement for a non-Michigan resident applying for a salesperson license. Which explanation reflects Michigan law, while the file concerns a student rental, assigned agency disclosure, and a cooperating brokerage? Option A. Establish a Michigan homestead. Option B. Appoint a county assessor. Option C. Open a branch office. Option D. Submit a consent to service of process. The correct answer is option D. Submit a consent to service of process. A non-resident applicant must provide a mechanism for legal process connected to Michigan regulation. The transaction context changes the facts, but it does not change the underlying licensing duty. Residency in the state is not itself a condition for salesperson eligibility. Question 20. Which compliance step is required when the transaction facts involve the allowed address arrangement for a salesperson or associate broker, while the file concerns a vacant commercial parcel, an online advertisement proof, and a rejected counteroffer? Option A. An out-of-state address automatically voids the license. Option B. A post-office box may be used. Option C. Every licensee must use a storefront. Option D. Only a broker company may use a post-office box. The correct answer is option B. A post-office box may be used. Individual salespersons and associate brokers have more flexible address options than brokerage offices. A written office procedure should produce the same result in comparable transactions. The mailing choice does not remove non-resident service process requirements. Question 21. A salesperson notices a potential problem involving the process used when a salesperson changes employing brokers. Which response should occur first, while the file concerns an industrial site, a listing agreement, and an assumed business name? Option A. Submit a ME+ modification request for a license transfer. Option B. File a new pre-licensure course application. Option C. Transfer the license through the county register of deeds. Option D. Keep both employers until renewal. The correct answer is option A. Submit a ME+ modification request for a license transfer. Employment changes are recorded through the state licensing system. In the described setting, the brokerage should document the step and apply it before moving forward. A deed-recording office has no role in transferring an occupational license. Question 22. The state portion of the exam presents facts about the status that may follow removal by an employer before expiration. Which result is supported, while the file concerns a new construction home, a lease application, and a security-deposit question? Option A. Permanent revocation. Option B. No employer status. Option C. Automatic broker status. Option D. Inactive county registration. The correct answer is option B. No employer status. Michigan does not offer a formal license minus escrow classification for salespersons. Applied to this scenario, the licensee should follow the rule before creating further obligations for a party. That status does not authorize independent real estate practice. Question 23. Which brokerage practice properly addresses the timing of the Michigan agency disclosure in the Battle Creek transaction, while the file concerns a mixed-use building, assigned agency disclosure, and a dual-representation concern? Option A. Before the prospect reveals transaction-specific confidential information. Option B. Whenever the licensee chooses. Option C. After the first offer is rejected. Option D. Only after closing. The correct answer is option A. Before the prospect reveals transaction-specific confidential information. Available agency relationships and their duties must be explained early in the interaction. For exam purposes, focus on the regulated relationship rather than an informal business custom. A closing-stage disclosure would come too late to protect informed choice. Question 24. A licensee is comparing 4 procedures related to the form of the required agency relationship disclosure. Which procedure is lawful, while the file concerns a cooperative unit, an online advertisement proof, and a protected-class inquiry? Option A. A written disclosure. Option B. An oral statement only. Option C. A note prepared after settlement. Option D. A social-media post. The correct answer is option A. A written disclosure. Michigan requires documentation of the agency information given to a prospective buyer or seller. The transaction context changes the facts, but it does not change the underlying licensing duty. Informal conversation alone does not satisfy the statutory format. Question 25. At the end of a seller consultation, the parties question acting for more than one party in a transaction without their knowledge. Which statement provides the best guidance, while the file concerns a farm parcel, a listing agreement, and a disputed repair credit? Option A, allowed if the property is residential. Option B, required in every transaction. Option C, prohibited conduct subject to discipline. Option D, permitted whenever commission is shared. The correct answer is option C, prohibited conduct subject to discipline. A licensee cannot secretly undertake conflicting representation. A written office procedure should produce the same result in comparable transactions. Compensation structure or property type does not eliminate the conflict.